Today for talk show host Maury Povich, where a 28-year-old producer filed a sexual harassment lawsuit against his talk show. The suit charges that the Maury show was a hostile work environment where, quote, hostility, intimidation, humiliation, ridicule, sexual harassment, as well as alcohol use was explicit, rampant, pervasive, and was condoned, unquote. Although the show's lawyers are denying those charges, it does bring up the question of what is acceptable in the workplace. Joining us now to talk more about this is Edith Pearce. She is a sexual harassment attorney with the Pearce Law Firm in Philadelphia. Nice to have you with us.
Good morning, Connie.
When we look at this case, and really in the suit for people who don't know, 28-year-old Bianca Nardi claimed that her boss, who was a producer on the show, not Maury, ordered her basically to wear short skirts, to wear push-up bras, at one time to take a shirt off so that they could shoot her breasts for one part of the show. Those obviously big red flags if those allegations are true. But it does bring up the question of what is sexual harassment, and I understand there are really two different types.
There are two different types. One is what we call quid pro quo. It's Latin for meaning this for that, which means if you engage in intercourse with me, I'll promote you. That's one type. The other kind is what we call hostile work environment, where things go on and it's regular and pervasive and happens over and over again. Maybe not the exact same kind of a thing, but different kinds of harassing things that create the environment at work to be hostile for the person. And that is the second type, and what kind we see most often.
It almost starts as something that's rather small, and then the person says, oh, that was acceptable to you, so I'm going to ratchet it up a little.
That is, and it gets more and more and more and stronger, and then eventually gets to the point where someone says, hey, you know, I shouldn't be putting up with this. I don't need to put up with this, and I need to do something about it. And that's when we get to the point where we see lawsuits filed and we see other kinds of claims being raised.
Let's talk about some of those subtle examples of things in the workplace that would be inappropriate sexual harassment.
Well, sometimes what happens is, let's say, a tugging of the hair or using pet names, the inappropriate pet names.
Sexual jokes.
Sexual jokes, touching, grabbing, caressing, and although maybe it might be laughed off at the time, it's considered inappropriate.
Even so much so if you say, so, you know, how was your weekend, and you kind of give them a back rub, that's really not appropriate at all.
That is not appropriate in work.
But you see that.
You do.
And I think you also see people who do that with no idea that they're doing something that really was not appropriate.
And that is one of the issues that the employers raise, is that, well, the person needs to let somebody know that they're objecting. Now, there are some things that are just obviously wrong and objectionable, but the more subtle things, the person needs to say, no, I don't like that, no, don't do that. And then what they also need to do is they need to pull out their employee manual and look at it and say, if I think this is inappropriate, it says I report it to my human resources or to my manager or whoever, but they need to pull out that book and look at it and do what it says.
And say where to go next. There are a lot of obvious ones out there, and they're being practiced quite often when you talk about grabbing and groping, and as you said, unwanted sexual advances, or if you do this for me, I'll do that for you. When you're in a situation like that, it usually ends up being with a boss or someone. So do you have the courage to go forward? And do you see in your practice a lot of people who do have the courage to go forward?
I do. I think that people get to the point where they say, enough is enough. I'm not going to put up with this. I shouldn't have to put up with this. And that's when they come and seek counsel and say, what should I do? The first thing I always say is, whatever you do, don't just quit. Stand up for yourself and make the report. You don't have to make it to the supervisor that's giving you a hard time or the manager that's giving you a hard time, but somebody else who's higher in the company that you feel comfortable making that report to.
But Edith, don't you find too that it never just stops there with, can you please, you know, it feels like it always has to go to a lawsuit, and it really doesn't, does it? I mean, even though I know you're a lawyer and this is what we do in your profession, for the employee, isn't there a guideline as well of don't, you know, report it, acknowledge it, put it on the table, fix it, but also to be able to continue to be a good employee? Is there an option for that?
Well, you know, it really depends on the company, because the companies generally have policies, or they should have a policy in place the way the law is set up, saying what somebody should do, and the law says that they cannot retaliate against somebody for making those kinds of complaints. Now, I have seen very good success stories where someone followed that, made the complaint, and they actually took care of it.
Dealt with it,
and then I've we were all very pleased, and
Right.
that's what happens. But then there's times when the companies refuse to acknowledge what's actually going on, and that's the circumstance when you see these head into lawsuits.
Okay. Edith, nice to have you here. Edith Pearce is a sexual harassment attorney from the Pearce Law Firm in Philadelphia. Over to you, Greg.
Okay, thank you.